Yeah, boy, that not drywall sure does smell bad. We're going to take it back. We're going to take back all this drywall. Now, you know that Mr. Copeland was calling Mr. Landers. Right? Calls Mr. Landers. Hey, Mr. Landers, you know that Chinese drywall we brought in? Boy, that's bad stuff. It smells. It smells really bad. As a matter of fact, I have a closing argument that I would use. You heard him say that. You heard Mr. Copeland say, if it were up to him, he'd have a closing argument. An opening and closing, he would say to the jury, here's American drywall, here's Chinese drywall. Smell it. Which one do you think the American home buyer would choose? A house built with a smelly Chinese drywall, with the smelly Chinese drywall, or the American drywall? You decide. That's what he said, Mr. Copeland. Mr. Pafina said, yeah. Remember him? He's the one that had the degree from the College of the Streets. He said, yeah, from Brooklyn. He said, yeah, if it smells bad, it's defective. So I called Mr. Landers and they're telling him this. This is what should have happened. Mr. Landers says, not good. It's not good. We got to tell people about it. We got to put people on notice. We got to warn people. We got to test this stuff. Find out what's going on. Why does it smell so bad? What's going on here? No, if you take this back, and I'm going to tell everybody. I'm going to tell the homeowners, I'm going to tell the builders, I'm going to tell the subcontractors that Knopf board stinks. And they shouldn't use it. And they shouldn't buy it. And they shouldn't install it. And if they have it in their homes now, take it out. Now. All right? They should have been ringing the bell. Loudly. Clang, 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 clang. Problem. Red flag. Stop. Stop now. Okay? That's what they should do. That's what a reasonable company should do for safety of consumers. It's a consumer safety case. For the safety of their property. For the safety of their financial interests. To prevent potential health concerns. That's what should have happened. All right, so as you can see on both clips on the Ford case as well as the drywall case, we start back with the theme, we reinforce the theme, and then we go over the testimony that supports the theme. But we do it in a conversational way. We talk to the jury. We don't read to the jury. We don't bore the jury. We actually have a conversation with the jury. We try to explain to the jury why we're right, and we persuade. So it's all about showing the very best of the case, not highlighting every single thing, and not reading back every single word. Summarizing it. If there's a zinger in there that the defendant used, you can quote that and show that. But always supporting it with your case theme. And arguing liability in such a way where justice requires that the result go the way you want, either being plaintiff or defense. It doesn't really matter. But you have to support that. And what I try to do in my plaintiff cases is I try to support my damages even throughout liability. As you could hear with both cases, I'm getting the jury interested and excited and empowered on what difference that they can make and why it makes a difference and how it will impact change in a very positive way without crossing the line, because you can't send a message unless you have a punitive damage case. You saw me walk that line on the Ford case, and you're seeing me walk the line here on this Chinese drywall case when I'm telling the jury how important it is. And I talk about it as a cover-up. The reason it was a cover-up, by the way, was the distributor got to return all of its bad drywall to the manufacturer and got American drywall. And they got compensated for the bad drywall that they were sold. But in return, they had to keep quiet, not tell anybody, not the news, not the media, not the websites, nobody, that there was a problem with the drywall. And they couldn't help their own customers. So it's a cover-up, Chinese drywall cover-up. And it stings. And I kept hitting with that over and over and over again. Closing argument, you tell a good story. You support it, wrap it with the law. You explain the elements of the law in a way the jury can understand it, or that fits your facts. I like using a lot of rhetorical questions. Is that right? Is that the right thing to do? Would a responsible company build a very weak roof that would squish like a pancake, knowing that SUVs roll over a lot and that the only chance you have for survival now that you're in a 3-point seatbelt is your roof? Does it make sense to have a very weak roof if they've known about it since the 1960s? Does that make sense? Is that right? Engages the jury, brings them in. Is it right to save your own skin when you sell defective Chinese drywall products? Get a refund for your drywall, return all your drywall, get paid, put it in your pocket, and basically screw the thousands of people you sold this product to, because you're not going to help them, and you're not going to tell them, and you're not going to tell the media. You're not going to let them return it while you keep the money. How many people think that's right? So I have a lot of fun with the rhetorical questions. Yes?
How did you put the dollar amount on the 1.4 loss of enjoyment of the house? How did you put that dollar amount in there?
What would a reason? With a lot of non-economic damages, I use a non-economic damage formula. I'm board certified in business litigation and general civil, and I do both. I'm old school. I grew up that way with my old firm, Fine Jacobson, Shorts, Nash, Block in England in the beginning of time. But I get to use a lot of the fun stuff I learned from PI work in my commercial cases, and I learned a lot of ways of using good documents and how to use documents in my commercial experience in my PI cases. And it's a very fun thing to do. But what I do is, let me give you an example. Person has, are you an athlete?
Yes.
Okay, what do you play?
Basketball.
Okay, all right. I may talk to the jury and say, this is a young man who is a lawyer, loved playing basketball and tennis. Had a devastating injury. He has to have rods in his legs. He can walk. You see him, one leg shorter than the other. He can practice law, sure. Some people think he's still handsome, looks great. He's got that rod in his leg. Walks with a limp. He can never play basketball again. Can never play sports again. Can never play tennis again. He sits there and he watches other people play and says, well, man, I really want to do that. He can't. He never will do it. When his little kid runs away from him, he can't go chase him. When his kid says, Daddy, why won't you play with me? He says, because Daddy's hurt. He's hurt forever. 24 hours every single day, 7 days a week, no vacations. And when he wakes up in the morning, guess who's there? Pain. Good morning. How you doing? I'm here. Why don't you take your pill? Every single day in the future, he's going to get arthritis in those joints. It's going to get worse. And it's going to hurt more. Every single day. Now, a lot of people would say, well, you know, I showed you those pictures of that rod. You saw those rods running down his leg? They'd say, well, you know, that's not so bad. Well, he lives this agony every single day. What reasonable person would say, well, you know what? Hey, why don't you take my leg and crush it? Smash it. Destroy it. And then you can get the best doctors in the world, like trying to put Humpty Dumpty back together again. We'll put these nice rods in there. Yeah. His leg will be a little shorter, but that's okay. He won't be able to play basketball or tennis or play with his kids anymore. He'll always have pain every single day. But that's okay. Because we're going to compensate. We're going to give him a couple $1 million. What reasonable person would say, yeah, take my leg, crush it, take away the things I love to do forever. Never give them back to me. Steal my health. Who would say, okay, I'll take a couple $1 million for that? So, I'm going to ask you at the end of this trial, which is now, after you saw all the x-rays and films and heard from the doctors, talked to my client, listened to his family, I ask you to come back with $2 million. More or less, that's how we do it. That's on the cuff, but obviously a little more preparation, but that's how I would do it. And with my commercial damages, other than hard numbers, which I present and support, if I have prospective damages or future damages, I try to work them that way. I engage the jury. I bring in the jury. I make you think. I get all the senses flaring. I get all the colors up. I support it with demonstrative aids. And I deliver the message strongly and boldly and not afraid of it. I have to believe that that's a fair number. Because if I believe it, I can get it for you. If I think I can't do it, or it's too high, or I'm snookering the jury, it won't happen. So I have to first convince myself it's a fair number for that injury, or a fair number for that loss. Then I can do it, because I mean it. And everything about me is telling you that. He means it. And I have to care, because if I don't care, why should the jury? So, be sincere, be prepared, be courageous, follow the fundamentals, and succeed. Thank you very much. On behalf of Patrick Montoya and myself, it's been a pleasure working with you today. And we'll stay around for questions.
I have one webinar question for you.
Yes.
It's how do we get a drug test admitted into evidence without having the lab or technician in court?
Well, you're going to need to have the lab or the technician in court.
That's the answer.
Yeah. You do it by deposition. By deposition.
Okay. Well, if that helps.
Yeah.